force. 3. Argument. Hurd argues that he is not charged under Texas Penal Code Section 49.04 together with 37 Texas Administration Code Section 3.23, 3.6, and 5.2, which gives the charging instrument force and effect of law under an SIC executive order. This argument is incomprehensible. This is a clear error of law. Hurd asserts that under Texas Code of Criminal Procedure Chapter 21.02 and 21.03, the Texas Administration Code associated with the charge of driving while intoxicated are to be included in the indictment. Texas Code of Criminal Procedure 21.02 and 21.03 discloses R21.02 requisites of an indictment. An indictment shall be deemed sufficient if it has the following requisites. 1. It shall commence, in the name and by authority of the state of Texas. 2. It must appear that the same was presented in the district court of the county where the grand jury is in session. 3. It must appear to be the act of a grand jury of the proper county. 4. It must contain the name of the accused, or state that his name is unknown and give a reasonably accurate description of him. 5. It must show that the place where the offense was committed is within the jurisdiction of the court in which the indictment is presented. 6. The time mentioned must be some date anterior to the presentment of the indictment, and not so remote that the prosecution of the offense is barred by limitation. 7. The offense must be set forth in plain and intelligible words. 8. The indictment must conclude, against the peace and dignity of the state. 9. It shall be signed officially by the foreman of the grand jury. R21.03. What should be stated? Everything should be stated in an indictment which is necessary to be proved. Hurd further asserts that 37 Texas Administration Code 3.23, 3.6, and 5.2 was to be included in the indictment in order to charge him with Texas Penal Code Section 49.04, which discloses the following. 37 Tex Admin Code Section 3.23, Citation and Custody Arrest. A citation. All traffic law enforcement officers of the Department of Public Safety will cite or arrest, as appropriate, all violators of the traffic laws apprehended by them who are committing a clear-cut and substantial violation of the traffic laws unless major extenuating circumstances are present. B. Custody arrests. 1. Custody arrests should only be used a. When necessary to have a violator forthcoming in court. B. To protect the violator or the public from injury. Or C. When required by law. 2. Under no circumstances will a custody arrest be used to punish the violator or as a convenience to the trooper. In obtaining information for a notice to appear in court, the violator is required by statute to furnish his name, residence address and date of birth. It is desirable to elicit pertinent information such as occupation, telephone number, and business address, etc., for possible future use in the processing of warrants. However, the violator's failure to respond in the latter instance is not, standing alone, a sufficient reason to make a custody arrest, for they are not legally compelled to provide such additional information. 37 Tex Admin Code Section 3.6, Crash Investigation Policy, a responsibility. The Texas Highway Patrol Division of the department is assigned the responsibility of investigating and properly reporting crashes involving motor vehicles which occur outside the city limits of an incorporated city upon a public road, highway, or other way or place open to the use of the public. B. Investigating and reporting. Upon notification of such crash, officers of the department will, insofar as practicable, make an on-the-scene investigation and properly report the results of their investigation without regard to the severity of the crash. See crashes in cities. 1. The department will not investigate motor vehicle crashes which occur in cities except in emergencies or where prior arrangements have been approved. 2. Any commissioned member of the department who witnesses or comes upon a motor vehicle traffic crash within the city limits will notify local officers and turn all information and control of the investigation over to them as soon as possible. Pending the arrival of the local officers, such department members will seek to protect the scene, render first aid or summon medical aid, detain involved drivers when necessary, and take any other action immediately needed for the public safety for which he has been trained and is equipped to perform.
Now this is what he doing. The dude had got in a crash, right? Mm-hmm. So when he got in the crash, the people who crashed into him left. He's still there, right? Mm-hmm. But he drunk. Okay. Now he out here on a federal He just got out of the feds, not any on supervised release. Okay, so what they do, they take him to the hospital and they blow him. Now what he's doing here is he's taking the regulations and he's saying the regulations supposed to be in his indictment. It was supposed to be in yours too. And the reason why is because it's telling you what all they have to do and what they can and can't do. Instructions. So if they do anything other than what they're instructed to do, they can't.
Everything's void.
It's done.
Everything's fruit.
You get what I'm saying? So this is what he's doing right now. Now, so when you go and continue to look at this and listen to it, he's going to go back to his prior conviction of a state charge because he knows that's what they're going to try to come back and hit him with. So he's going to do the same thing. He's supposed to be doing it. He's supposed to be doing the same thing in here, just in case they come and try to hit him with his prior, what he's out there on in the first place, and say, well, you got a prior conviction and this and that and the other, and we're going to hit you with this. And he's going to say, well, his prior conviction ain't nothing either. You know what I'm saying? Because you don't have jurisdiction over it. And this is what he's supposed to be writing in here. So what he did was he wrote it and he turned around and wanted me to look at it and evaluate it. I'm gonna read it one more time and then I'm gonna go back over it.
All right, let me know when you want me to start it.
Okay. You ain't gotta start.
Okay.